federal government cannot be coercive through the spending clause. What do you think we were? Give us a hypothetical.
Yeah. First, if I could just try to be a little more precise about it, Justice Scalia, I think what the Court said in Stewart Machine and in Dole is that it's possible that you might envision a situation in which there's coercion.
Okay.
And the Court didn't say much more. But I can think of something. One example I could think of that might serve as a limit would be a COIL-type situation in which the condition attached worked a fundamental transformation in the structure of state government in a situation in which the state didn't have a choice but to accept it. But
anything else, so long as
but I think
they have to. You're talking about a situation where they have to locate their state house in some other city,
or a unicameral
legislature. But short of that, they can make the state do anything at all.
Well, no. The Dole conditions are real. The germaneness condition in Dole is real, for example, and so those.
But none of those have addressed the coercion question.
Right.
So, do you think it would be all right for the federal government to say, same program, states, you can take this or you can leave it. But if you don't take it, you lose every last dollar of federal funding for every program.
I think that would raise a germaneness issue, Mr. Chief Justice, but it's not what
but there's no coercion question at all.
Well, but I think they're related. I think that the germaneness inquiry in Dole really gets at coercion in some circumstances, and that's why I think they're related. But we don't have that here, and if I could, I would like to.
No, I know we don't have that here. How does germaneness get to?
Well, because it gets to be harder to see.
That's germaneness. Right. There's no
what the connection is between getting you to do A and the money.
So it fails because it's not germane, but you're saying it would not fail because it was coercive.
Well, I think that, as I said, I think they're really trying to get at the same thing, but I do think it's quite different here. And I would like to, if I could, take up.
No, I know it's different here. I'm just trying to understand if you accept the fact, or regard it as true, that there is a coercion limit, or that once you're taking federal government money, the federal government money can take it back, and that doesn't affect the voluntariness of your choice. Because it does seem like a serious problem. We're assuming under the spending clause the federal government cannot do this. Under the Constitution it cannot do this. But if it gets the state to agree to it, well, then it can. And the concern is if you can say, if you don't agree to this, you lose all your money, whether that's really saying the limitation in the Constitution is largely meaningless.
Well, but I don't think that this is a case that presents that question.
No, I know. I know this. I won't know if I'll grant it to you or not, but let's assume it's not this case. Do you recognize any limitation on that concern?
I think the Court has said in Stewart, Machine, and Dole that this is something that needs to be considered in an appropriate case, and we acknowledge that. But I do think it's so dependent on the circumstances that it's very hard to say in the abstract with respect to a particular program that there is
you can't imagine a case in which it is both germane and yet coercive, is what you're saying. There's no such case as far as you know.
Well, I'm not prepared to say right here that I can
I wouldn't think that's a surprise question.
But I think Congress has authority to act.
I can't think of one. I'm not blaming you for not thinking of one.
But I do think, and I really do think that it's important to look at this. An issue like this, if you're going to consider it, it's got to be considered in the factual context.
Well, let me give you a factual context. Let's say Congress says this to the states. We've got great news for you. We know that your expenditures on education are a huge financial burden. So we're going to take that completely off your shoulders. We're going to impose a special federal education tax, which will raise exactly the same amount of money as all of the states now spend on education. And then we're going to give you a grant that is equal to what you spent on education last year. Now, this is a great offer, and we think you'll take it. But, of course, if you take it, it's going to have some conditions, because we're going to set rules on teacher tenure, on collective bargaining, on curriculum, on textbooks, class size, school calendar, and many other things. So take it or leave it. If you take it, you have to follow our rules on all of these things. If you leave it, well, then you're going to have to tax your citizens. They're going to have to pay the federal education tax, but on top of that, you're going to have to tax them for all of the money that you're now spending on education, plus all of the federal funds that you were previously given. Would that be the point where financial inducement turns into coercion?
No, I don't think so, because the states do have a choice there, especially as a going-in proposition. I mean, the argument the states are making here is not that this is not a going-in proposition. Their argument is that they are in a position where they don't have a choice because of everything that's happened.
Well, you might be right, but if that's the case, then there's nothing left
but as a
federalism.
As a practical matter, I disagree with that, Justice Alito. First of all, as a practical matter, there's a pretty serious political constraint on that situation ever arising, because it's not like the federal government is going to have an easy time of raising the kinds of tax revenues that needed to be raised to work that kind of fundamental transformation, and that's real, and political constraints do operate to protect federalism in this area. And
I would have thought there was a serious political constraint on the individual mandate, too, but that didn't work.
Well,
what you call serious political constraints sometimes don't work.
But with respect to a situation like that one, Justice Scalia, the states have their education system, and they can decide whether they're going to go in or not. But here, of course, I think it's important to trace through the history of Medicaid. It is not the case, as my friend from the other side suggested, that the norm here is that the federal government has offered to the states the opportunity either to stay where they are or add the new piece. We can debate that proposition with respect to 1972 one way or another. The states have one view about that. We have a different one. But starting in the 1984 expansion, with respect to pregnant women and infants, it was an expansion of the entire program. States were given the choice to stay in the entire program or not. 1989, when the program was expanded to children under 6 years of age, under 133% of poverty, same thing. 1990, kids 6 to 18 and 100% of poverty, same thing. In fact, every major expansion, same thing. And so I just think the history of the program, and particularly when you read that in context of 42 U.S.C. 1304, which reserves the right of the federal government to amend the program going forward, shows you that this is something that the states have understood all along. This has been the evolution of it. And with respect to...
Could you give me some assurance? We heard the question about whether or not the Secretary would use this authority to the extent available. Is there circumstances where you are willing to say that that would not be permissible? I'm thinking, well, the Arizona letter, for example. I mean, if I had the authority and I was in that position, I would use it all the time. You want some little change made? Well, guess what? I can take away all your money if you don't make it. You know, I win. And every time it seems that would be the case. So why shouldn't we be concerned about the extent of authority that the government is exercising simply because they could do something less? We have to analyze the case on the assumption that that power will be exercised, don't we?
Well, Mr. Chief Justice, it would not be responsible of me to stand here in advance of any particular situation coming before the Secretary of Health and Human Services and commit to how that would be resolved one way or another.
No, I appreciate that. But I guess
is there in the statute, and I think there's every reason to think it's real. But I do think, getting back to the circumstances
well, General, what's been the history of its use? Has the Secretary, in fact, ever made use of that
authority? That's
correct,
Justice Kagan. It's never been used.
What about the Arizona letter we just heard about today?
It has never been used to cut off.
It's been used to threaten. It's been used. Of course, no state's going to say, "Okay, go ahead, make my day, take it away." They're going to give in.
If we could go to the situation we have here, Mr. Chief Justice, this, with respect to the Medicaid expansion, the state's argument is, as they've said it in their briefs, they articulated a little bit different this afternoon, but as they said it in their briefs, it's not what you stand to gain, but what you stand to lose. But I think an important thing in evaluating that argument in this context is fully 60% of Medicaid expenditures in this country are based on optional choices. And I don't mean by that the optional choices of the states to stay in the program in 84, 88, or 89. But states are given choices to expand the beneficiaries beyond the federal minimum and to expand services beyond the federal minimum.
Just a small point, and please correct me if I'm wrong. Does this Act not require states to keep at the present level their existing Medicaid expansion? So some states may have been more generous than others in Medicaid, but this Act freezes that so the states can't go back. Or am I incorrect?
Much more nuanced than that, Justice Kennedy. There is something called the maintenance of effort provision, which lasts until 2014, until such time as the Medicaid expansion takes place and the exchanges are in place. that applies to the population. It says with respect to the population you can't take anybody out. It does not apply to the optional benefits, where the states still have flexibility. They can still reduce optional benefits that they're now providing if they want to control costs. They can also work on provider rates. There's also, with respect to demonstration projects by which some states had expanded their populations beyond the required eligibility levels, they don't have to keep them in. So, and then there's also, if the state has a budgetary crisis, it can get a waiver of that, as Wisconsin did. So that's a provision, I think, that does a significant degree less than my friends on the other side have suggested in terms of its effect, and its effect beyond that is just temporary. But I do think, with respect to the first of their three arguments for coercion, the sheer size argument, that it's very difficult to see how that is going to work, because if the question is about what you stand to lose rather than what you stand to gain, then it seems to me that it doesn't matter whether the Medicaid expansion is substantial or whether it's modest or whether there's any expansion at all. The states, for example, the federal government, for example, could decide that under the current system, too much money has ended up flowing to nursing home care, and that money would be better in serving the general welfare if it were directed at infants and children. But if the federal government said we're going to redirect the spending priorities of the federal money that we're offering to you, the states could say, well, geez, we don't like that. We'd like to keep spending the money the way we were, and we have no choice because this program has gotten too big for us to exit. And in fact, it seems to me, standing here today before these expansions take place under their theory, the provisions coercive.
The smaller it is, the bigger the coercion.
Right. Well,
the smaller what you're demanding of them, the bigger the coercion to go along.
The more they stand to lose. And then I think I'm sorry.
Just before you leave that, I'd appreciate it if you would expand a little bit on the answer to Justice Kagan's question. For the reason, when I read the cutoff statute, which, as I said, has been there since 1965, unchanged, it does refer to the Secretary's discretion to keep the funding insofar as the funding has no relationship to the failure to comply with the condition. And as I read that gives the Secretary the authority to cut off all the money that the state's refusal to accept the condition means they shouldn't have. But nothing there says they can go beyond that and cut off unrelated money. Now, there is a sentence that says maybe they could do that. But I thought they had to exercise that within reason. I don't know when it would be reasonable. So you've looked into it. And that's what I want to know. Is there, I could find no instance where they went beyond the funds that were related to the thing that the state refused to do, or things affected by that. But I would like you to tell me, when you looked into it, that what I thought of in this isolation chamber here is actually true, or whether they have gone around threatening people that we will cut off totally unrelated funds. What is the situation?
So I think the situation is generally as you've described it, but I do want to be careful in saying I don't think it would be responsible of me to commit now that the Secretary would exercise the discretion uniformly in one way or another.
But that's just saying that when, the analogy that's been used, the gun to your head, your money or your life, you say, well, there's no evidence that anyone's ever been shot. Well, it's because you have to give up your wallet. You don't have a choice. And you cannot represent that the Secretary has never said, and if you don't do it, we're going to take away all the funds. They cite the Arizona example. I suspect there are others, because that is the leverage.
But
I'm not saying there's anything wrong with it.
It's not coercion, Mr. Chief Justice.
Wait a second. It's not coercion. Well, I guess that's what the case is. It's not coercion to say I'm going to take away all your funds, no matter how minor the infringement.
But of course,
I don't know if that's so. And all I asked in my question was I didn't ask you to commit the Secretary to anything. I wanted to know what the facts are. I wanted to know what you found in researching this case. I wanted you to, in other words, to answer the question the Chief Justice has. Is it a common thing that happens, that this unrelated threat is made, or isn't it?
So my understanding is that these situations are usually worked out back and forth between the states and the federal government. And I think
you're not privy to the.
And I'm not. And
who wins?
Well, I think that's what I think is the problem here, Justice Scalia. It seems to me we're operating under a conception that isn't right. The reason that we've had all these Medicaid expansions, and the reason it seems to me why we are where we are now, and why 60% of what's being spent on Medicaid is based on voluntary decisions by the states to expand beyond what federal law requires, is because this is a good program and it works, and the states generally like what it accomplishes.
Mr. General, really, is this discussion realistic? The objective of the Affordable Care Act is to provide near universal health care. Now, suppose that all of the 26 states that are parties to this case were to say, well, we're not going to abide by the new conditions. Then there would be a huge portion, a big portion of the population that would not have health care. And it's a realistic possibility that the Secretary is going to say, well, okay, fine, we're going to cut off your new funds, but we're not going to cut off your old funds, and just let that condition sit there?
Well, just as I can't make a commitment that the authority wouldn't be exercised, I'm not going to make a commitment that it would be exercised. But I do think that trying to move away from the first of their arguments, the sheer size argument, to the second one, which is that it's coercive by virtue of its relationship to the Affordable Care Act, I really think that that's a misconception, and I'd like to be able to take a minute and walk through and explain why that is.
General Verrilli, before you do that, I'm sorry, but in response to the Chief Justice's question, I mean, the money of your life has consequence because we're worried that that person is actually going to shoot. So I think that this question about what do we think the Secretary is going to do is an important one. And as I understand it, I mean, when the Secretary withdraws funds, what the Secretary is doing is withdrawing funds from poor people's health care, and that the Secretary is reluctant and loath to take money away from poor people's health care, and that that's why these things are always worked out. It's that the Secretary really doesn't want to use this power, and so the Secretary sits down with the state and figures out a way for the Secretary not to use the power.
That's correct, Justice Kagan.
Sorry, go ahead.
That's another way of trying to say what I was trying to say to Justice Scalia earlier, is that the states and the federal government share a common objective here, which is to get health care to the needy. And in the vast majority of instances, they work together to make that happen.
Yeah, but the question is not, obviously the states are interested in the same objective, and they have a disagreement, or they have budget realities that they have to deal with. And states say, well, we're going to cut by 10% what we reimburse this for or that for, and the federal government says, well, you can't. And no one's suggesting that people want to cut health care, but they have different views about how to implement policy in this area. And the concern is that the Secretary has the total and complete say, because the Secretary has the authority under this provision to say you lose everything. No one's suggested in the normal course that will happen, but so long as the federal government has that power, it seems to be a significant intrusion on the sovereign interest of the state. Now, it may be something they gave up many decades ago when they decided to live off federal funds, but I don't think you can deny that it's a significant authority that we're giving the federal government to say you can take away everything if the states don't buy into the next program.
Well, but what I would say about that, Mr. Chief Justice, is that we recognize that these decisions aren't going to be easy decisions in some circumstances. As a practical matter, there may be circumstances in which they're very difficult decisions. But that's different from saying that they're coercive, and it's different from saying that it's an unconstitutional.
Why is it different? Why is it different? I mean, I thought it might be very unlikely a state would ever say, or the federal government would say, here's a condition that you have to have a certain kind of eyeglasses for people who don't see. And by the way, if you don't do that, we'll take away $42 billion of funding. Okay? I thought such a thing would not happen. And I thought if it tried to happen, that it's governed by the APA, and the person with the eyeglasses would say it's arbitrary, capricious, abuse of discretion. And that's so, even though the statute says it's in the discretion of the Secretary. But your colleague and brother says, no, I'm wrong about the law there, and moreover, they would do it. That's what I'm hearing now.
No,
they would do it, and they do it, and et cetera. So I'd like a little clarification.
In the situation described in your hypothetical, Justice Breyer, I think it's the Secretary of Health and Human Services would never do it. But what I'm saying is with respect to the Medicaid expansion in this case.
Could never do it or
would never do
prediction.
it. And I think that it would have to satisfy the Administrative Procedure Act, and that's a real constraint. What I don't feel able to do here is to say with respect to this Medicaid expansion.
Are you willing to acknowledge that the Administrative